Hey people, it's Nias talking. Now, recently something piqued my interest when Donald Trump said he was gonna revoke birthright citizenship. Now, it was, according to him, commonly claimed that it could be done with only with a constitutional amendment, but he claimed that all it needed was a presidential, what was it, an executive order to do that. Now, that isn't the case, but a lot of people then brought up something which was called Calvin's case, which is a case from English law which carried over into US law. And being in this channel, I often like to go and talk about things we don't often hear. I wanted to cover this. So this is from Wikipedia, which is one of the easiest sources to cover because it's brief and gets to the point. So this is starting from the top. Calvin's case, also known as the case of the Post Nati, was a 1608 English legal decision establishing that a child born in Scotland after the union of the crowns under James VI and in 1603 was considered under the common law to be an English subject and entitled to the benefits of English law. Calvin's case was eventually adopted by courts in the United States, and the case played an important role in shaping the American rule of birthright citizenship via jus soli, law of the soil, or birthright citizenship, or citizenship by virtue of birth within the territory of a sovereign state. However, the case has also been cited as providing legal justification for the restriction of legal rights to Native Americans following the widespread conquest or confinement in reservations by the colonial forces of North America. Under the feudal system, the allegiance owed to a king by his subjects, connected as it was to the holding of interest in land, ruled out the possibility of any given individual holding land in two different kingdoms. Robert Calvin, born in Scotland around 1606, inherited estates in England, but his rights thereto were challenged on grounds that as a Scot he could not legally own English land. As it happened, the child of Robert Calvin was actually named John James Colville. He was the son of Robert Colville, Master of Culross, and grandson of the courtier James Colville, First Lord Colville of Culross. The Court of King's Bench ruled in Calvin's favour, finding that he was not an alien and did have the right to hold land in England. Although not directly relevant to the case, Edward Coke used the occasion to discuss the portion of perpetual enemies, specifying all infidels are in law perpetuity in intimacy perpetual enemies. Having accepted that a king who conquers a Christian kingdom is constrained by the continuance of such laws as exist until new laws are put in place, he continues, however, if a Christian king should conquer a kingdom of an infidel and bring them under his subjection, therefore, ipso facto, the laws of the infidel are abrogated, for that they be not only against Christianity, but against the laws of God and nature. Robert A. Williams, Jr. argued that Coke used this occasion to quietly provide a legal sanction for the London Virginia Company to dispense with affording Native Americans any rights as they settled in Virginia. Again, this is the use of Christianity to take away the rights of black and brown peoples. But we don't want to get into that. That's a whole nother avenue. In the Indracht case, King Charles reconfigured the ruling for New England. The test case went to a panel of 14 judges drawn from different courts. Two of those dissented, Sir Thomas Foster, 1548 and 1612, and Sir Thomas Walmsley. Significance, the Post Nati and Ante Nati. The decision in Calvin's case hinged on Calvin's status as one of the Post Nati, subjects born into the allegiance of the Scottish King James after he had become the King of England in 1603, and on the fact that the monarch into whose allegiance he was born, the same James in the capacity as King of Scots, was also the English king at the time of Calvin's birth, meaning that Robert Calvin, in the judgment of the court, was just as much a subject of the King of England as if he had been born in England instead of Scotland. The judges of the court cited existing statutes, including particularly a 1351 statute, De Natis Ultramare, which granted the benefits of subject status to foreign-born children of the king's subjects, as supporting the concept that allegiance was tied to the person of the king rather than the kingdom itself or to its laws. Calvin's case did not extend English subject to the Ante Nati, Scots born prior to 1603. They remained aliens in relation to England on the view that King James had not yet become the King of England at the time of their birth. Attempts had been made in English Parliament prior to Calvin's case to naturalize all of James's Scottish subjects, both those born after his English accession in 1603, the Post Nati, and those born before 1603, the Ante Nati. but these legislative efforts had been unsuccessful. Concerns had been expressed that extending the privileges of English subjects to all Scots would cause England to be flooded by an influx of hungry Scots. It's funny. There's a lot of parallels to this. Like, if you give the Scots, they'll come over and take away all the good stuff that the English have, and then you have in America. Well, if we let the blacks have the same citizenship and the same rights, they'll take everything away from us. I think there's a lot of... It's quite funny. The more things change, the more they stay the same. Or now it's gone for blacks to also blacks and Mexicans. Also, objections were also raised that granting naturalization to all the Scots would encourage the legal philosophy espoused by James of absolute monarchy and the divine right of kings. Even after Calvin's case, the English Parliament could have acted a naturalization bill covering the anti-natty, but it never did so. Calvin's case contributed to the concepts of the rights of Englishmen. Some scholars believe that the case did not fit America's situation for the reason that the 18th century colonists could claim all the rights and protections of English citizenship. In fact, one scholar asserts that the legal apologists for the American Revolution claimed that they improved on the rights of Englishmen by creating additional purely American rights, whatever that means, owing to its inclusion in the standard legal treaties of the 19th century compiled by Edward Coke, William Blackstone, and James Kent. Calvin's case was well known in the early judicial history of the United States. Consideration of the case by the United States Supreme Court and by state courts transformed it into a rule regarding American citizenship and solidified the concept of jus soli, birthright citizenship, as a primary determining factor controlling the acquisition of citizenship by birth. Okay, now we've read that. I'll put that in the description so you can read it. Now, I want to read the relevant section of the 14th Amendment that causes the most arguments. This is from Britannica.com. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of its laws. So, there are three things that are the sticking points in this. The subject to the jurisdiction thereof. You see, people say that if you're an illegal immigrant, you have broken the laws of the United States and they do not cover you and you are not wanted there. Therefore, you are not covered by those laws, and therefore you are not covered by any law saying that you become a citizen simply because you were born there, because your parents were there illegally. If you imagine like saying, well, if I stole something, let's use this example. It's like saying if you stole something and then passed it down from father to son to grandson, and then said, well, I've had it for so long, it's mine. That's kind of the argument some people would use. Some people say they're using that, well, I've been here so long, my son was born here. Well, your son, if you hadn't broken the law, wouldn't be here. Therefore, he is just as illegal as you. Now, I'm not a legal scholar, and this is a question for the Supreme Court and maybe the legislature to decide. And another thing is here that it does now, some people, when I was in the comment section and talked about 14th Amendment, they said, read it, it was made for black people. Now, if we can get into original intent, and maybe that the original intent was to give citizenship to black people born in the United States who were freed after slavery and to just clear up their legal status. But it does not say anything about black people. So that does not make it exclusive to black people, and that birthright citizenship could technically be applied to everybody born within the territory of the United States. And the equal protection aspect of the laws, which is extremely complicated. Now, I'm sure we don't have to get into why, but that is complex, because if you just watch the news over the last 30, 40, 50 years, you will have understood that by now. Anyway, this is probably going to get a bit long. So anyway, I hope you've enjoyed this and you've learned something. And so if you like this, please comment, rate, share, and subscribe. I'll leave my Instagram in the description. If you want to support this channel, leave the PayPal, and I'll leave the Wikipedia and this Britannica site and maybe some others. So peace, family.